Namaste students. Today's our topic is property of a Hindu female dying intestate. Section 15 of the Act. A definite and uniform scheme of succession of property of a Hindu female who dies intestate. Section 16 of the Act sets out of the order of succession of the heirs of the Hindu female and is to be read along with section 15 of the Act setting out the general rules of succession. However, section 15 of the Act has failed to consider the equity of the fate of the self-acquired property of a Hindu female dying intestate. The legislatures, while framing the legislation, did not contemplate at that time that Hindu females would hold self-acquired property. The term property, although not specifically defined by the Act, for the purpose of section 15 of the Act, means the property of the deceased Hindu female heritable under the Act. It includes both movable or immovable properties on and acquired by a Hindu female by virtue of inheritance or at partition or by gift or by purchase. The section does not differentiate between the property inherited by a Hindu female and the self-acquired property of a Hindu female. It only prescribes that if property is inherited from the husband or father-in-law, it would go to her husband's heirs, and if the property is inherited from her father or mother, in that case, in the absence of her issue, the property would not go to her husband or his heirs, but to the heirs of her father. The current position in law for self-acquired property of Hindu female dying intestate. A situation where a married Hindu female dies intestate, leaving behind herself acquired properties, we shall assume she had no issue and was a widow at the time of her death. As per the present position of law, her property would devolve in the second category, that is, to her husband heirs, that in case the mother of her husband is alive, the deceased Hindu female entire self-acquired property would devolve on her mother-in-law. The mother-in-law is also not alive. It would devolve as per the rules laid down in the case of a Hindu male dying intestate. If the father of her deceased husband is alive, the next in line to inherit the property will be her father-in-law. And if the father-in-law is also not alive, then her property would devolve on the brother and sister of the deceased husband. Thus, the entire self-acquired property of the Hindu female would vest in the brothers and sisters of the predeceased husband and not that of the Hindu female, even if she has siblings that are alive. Therefore, where a Hindu female dies intestate, leaving behind herself acquired property, and in case where her heirs in the first category fail, her property will devolve totally upon her husband's heirs, who may be very remotely related or probably even unaware of each other's existence.